I would like to reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
May it please the court. As I said, I represent Clarksville-Montgomery County School System, and we're here today appealing the decision from the Chancery Court and asking that the court overturn the decision, and I'm going to go through, I think, 2 ways that the court can reach that conclusion and overturn the decision. And this is from a new chancellor.
Excuse me just a second. Judge Ash, would you do the court a favor and close that door, please? Yes, sir. Thank you so much.
Yep.
I knew you would come in handy sometime today.
So this is from a new chancellor, and this case, from a small extent, had an original chancellor, then there was a change in the middle, then it continued on with a new chancellor. So the 2 avenues I think the court can look at. First, the chancellor here, and you read the opinion. This is a school system employee discipline, and so there are particular statutes that apply. And it was a 1-day, and under the statutes, which I'll go through in a minute, 3 days or less has less protections than a tenured employee that's getting a 1 year, more than 3-day discipline. So this ultimately turned out to be a 1-day discipline for an employee with no recommendation of termination or any other action. And so when the timeline quickly, and I realize this is all in the brief, and so, but I think it's relevant, and these are all in 2022. February 23, there was an issue that was brought to the IT department's attention that there might be a potential FERPA violation, FERPA being Family Education Rights Privacy Act. There, I got it. Involving a teacher, Miss Byrd. And so the next day there's a meeting, that's February 24th, with the principal, Miss Byrd, David Holman, the chief of the IT department, and 2 others. And at the conclusion of that meeting, there was a recommendation from the principal that the teacher get a letter of reprimand for 1 day. So that kind of what sets us in motion. And so then under the statutes, the plaintiff, Ms. Byrd, received the letter. She requested a meeting with the director of schools, and that happened on March 29th. So all that's done timely. And following the meeting with the director of schools, to which Ms. Byrd had an attorney present at the time, ultimately a letter from April 6th came from the director upholding the 1-day suspension of Ms. Byrd. So that was on April 6th, and then on May 4th, Ms. Byrd sent a letter to the clerk and master that kind of starts this process. And then on May 11th, Dr. Huff, the director, was served with a summons. So once we get to the court, and so the 2 avenues, I think the court didn't have jurisdiction to even hear the case, but let's come back to that. The second part of it is, what was the role of the chancellor when he heard the case? And so when these type of cases, what the court is doing is reviewing the record. The first thing that you have in these type of writ matters is, what's the record? What was the evidence? And so the evidence was filed in the court, and so that's what the statute says should be reviewed. Was there a basis for the director of schools to issue a 1-day letter of reprimand? That's really what we're looking at. Is there a basis in the record? Not to include other things outside the record unless it's to show that it was arbitrary and capricious. And there are information in the record that the chancellor should have relied on to find that it's justified. And so the 2 things that I think are relevant about that are 2 statements from David Holman, get my tabs right, who was the IT director, who was present in that initial meeting, where he wrote into the record, which ultimately became part of the reason there was a decision, that he had expressed concerns with Ms. Byrd that the website that her and her husband had created were used the district's name without permission, but that the husband had access to student information being stored on a computer outside the district, because they downloaded information out of something called Power School, which is used to administer all the grades and discipline and everything about a student. So there's a lot of information in
And
there.
it's my understanding the husband admitted that Ms. Byrd provided him with the information.
Yes, and in that initial meeting on that first day with the principal back February 28th, Ms. Byrd also told that. And she was asked, and this Mr. Holman's memo, part of the record, I asked Rebecca how her husband had access to Power School information, and she said he was using her credentials to obtain the information. And that same type of statement is also Stephen Lynn, who's also from the IT department, was present at the initial meeting. He also writes a separate memo kind of outlining what happened. And he said Rebecca stated that her husband did have Power School login credentials in order to get the student information. And
But
so
this was all done for school purposes, right?
yes, I don't think she was trying to do something
She
nefarious.
wasn't doing anything nefarious. She was trying to set up some sort of communication system with parents, and she didn't have all the technical ability, and so she called on her husband to help. Is that really what this boils down to?
That is what it boils down to. And so every year we remind teachers that there's certain obligations we have as a district to protect, and as employees they have to protect certain information. There's very limited thing that's not protected. And so giving her husband access to Power School, which contains all kinds of other information, is a violation of FERPA. And the court recognized
Can't a teacher have a teacher's assistant that helps with certain things?
which would also be an employee of the district and would be under the same subject rules and regulations.
So the fact that he was acting essentially as her agent is irrelevant to the confidentiality statute.
Correct, because he doesn't have, as an agent, any type of agreement or obligation with the school system to protect this. Now here, fortunately, nothing happened. Although it was published on the web, it was password protected, and it didn't go any further. So now we look at, okay, why did the director make a decision? Well, the director made a decision because there was a violation of FERPA, and we are telling a teacher who, from the record, is a good teacher, you made a mistake, don't do it again, you get a one-day suspension, and come back tomorrow, and we'll all go on. She's still working for the district. There was no termination. And the chancellor found in record, referenced in two different places, that he also found that there was a technical violation of FERPA. And so when we look at what is that, the initial decision by the chancellor, it is, was there something to support the decision of the director? And there is information to support this decision. We don't want the courts to micromanage school districts. There are some things that the districts have to do themselves, and they make judgment calls. Is it important to protect student information? Well, it's federal law, so yes. Is this a minor violation? It was. Did we reprimand her for one day? Yes, we did. That's the type of minor thing that the statute says that we should do. So the court, when they're looking at it, there was information in the record to support the decision. That's where the analysis for the court should have stopped. Not, as the court says in their decision, well, I went and looked at some other FERPA policies of different districts. I researched it myself. Mr. Nolan, I want you to explain to me, and asking questions, what other things could they have done? Could they not have just called her in and talked to her? Can we allow the husband to testify over objection? And so the court does a number of things, but they're beyond the scope, and quite frankly, if you read the order, it goes beyond what is allowed and contemplated by the statute.
If the school system doesn't take action against people who make even technical violations, some sort of action, that has consequences for the school system, does it not?
It does, and the school system, and of course this is outside the record, but the school system is involved in other litigations where other litigation where a student has alleged and sued the district, my information was put out there. So the district is aware that we have an obligation to protect.
Does the district, if the district doesn't protect this information, are there consequences from the state or from the federal government, like cutting funds or anything like that?
I mean, I don't know.
Okay.
So
That's
I
fine.
don't want to tell the court one way or another. I don't have that information. But it is a federal law that information has to be protected.
Your leading arguments are subject matter jurisdiction, of course.
Yes.
And I want to make sure that we talk about that before your time runs out completely. One of the things that you point is a lack of an oath or an affirmation. And you rely on the Cooper against Williamson County Board of Education case for the proposition that review under the Teacher Tenure Act is a species of writ of certiorari, and then go on to say, well, and we all know writs of certiorari must be sworn or on oath. But, you know, the Cooper case really never addresses that. It's all about the scope of review for the trial court. And there is a statute in the Teacher Tenure Act that says what must be included in the petition, and I don't know that it mentions an oath or an affirmation. I mean, so how do we, I mean, do we go with the statute? If a Supreme Court says, our Supreme Court says it's a species of writ of certiorari, does that necessarily imply that it has to meet all the requirements of the common law writ under our Constitution?
I think it does, but 49.5.13, the statute we're talking about, does set forth the petition shall be filed within 30 days upon receipt of the teacher. The petition shall state, number one, the issues involved. Number two, the substance of the order or what the petitioner is claiming was wrong with the order. And number three, pray that the chancellor review it. It also says the petition shall be addressed to the presiding chancellor and shall state the names of the defendants' board members. What we got, and this is why I say the court doesn't have jurisdiction, we've raised it all along, is a letter to the clerk and master asking for extra time. If you go through the record, nowhere in the record is there a complaint. We have to initiate a lawsuit. And there was never anything that could be, by any stretch of the imagination, called a complaint, called a writ.
But isn't it fair to say her letter did include, I mean, it has attachments, right? So it's pretty clear what decision is being, review is being, she's concerned about. I mean, isn't that?
The letter, Your Honor, is a one-page letter to the clerk asking for extra time. And in my brief, I outlined and cited cases to show you can't initiate a lawsuit with a motion. And that's what we have here. This, at best, this is a motion for extra time. The plaintiff, when we were talking about the record and when she went to before Dr. Huff and she had an attorney, she said, and this was in the record, her attorney said, I also want the record to reflect that my client has a mental disorder, not a disability, that actually makes it quite difficult, actually impossible for her to lie or to break a rule because her mind is wired that way. And the plaintiff injected and said, obsessive compulsive personality disorder. It's horrible, so when they tell me to follow a rule, I have to follow it. This statute says you must initiate a complaint, you must file a writ within 30 days, and the plaintiff didn't do that.
Well, I guess, but I'm looking at the record now, and it looks like there's an Exhibit 1 and Exhibit 2 attached to this one-page letter. Is that not accurate? And it looks like those letters are on the school system's letterhead.
Yeah, I think it's the letter from the director.
Yes, letter from the director, but there's also, it looks like both the letters look like they're from the interim director of schools. one appears to be the initial discipline, and the second seems to be, and we've reviewed it, and we're confirming the initial suspension, the one-day suspension here. So, I mean, I guess my overall question here by pointing that out is, could we not piece together from those two exhibits what this is all about, sufficient to comply with the statute at least?
Well,
Setting aside for the second the question about whether or not an oath for affirmation is required.
I don't think it is the obligation of the defendant to try to piece together and guess what it is about.
Well, that's where Rule 12 motion for a more definite statement might come in. So,
Well, and I realize I'm over my time, and so I will. Even that initial plea, that initial summons, we filed a Rule 12 motion regarding sufficiency of service of process because we were just served with a summons, no attachment. So when we appeared in the court initially, we didn't even know what it was about. We knew that there was a summons. And so to say, well, the defendant now has to go to the court and on its own investigate what was filed and now try to extrapolate what the plaintiff meant and what they're appealing when it doesn't comply with the statute is a burden that's not on the defendant, not on the school system.
All right, Mr. Nolan, thank you. We'll hear from you on rebuttal. Ms. Byrd? Good morning. For your benefit, there's a timer right there, and it has a red, yellow, and green light. And the green light obviously means go, but the yellow will give you a 1-minute warning that when your time is expiring.
Okay. Good morning. I have one quick question.
Yes.
Please tell me that J means judge and not all of you have the same initials at the very beginning.
Well, it's a deep secret. We can't.
Okay, I just wanted to know. Hi, my name is Rebecca Byrd, and if it pleases the court.
The answer is yes, Judge. So
I was hoping so, because I was like, James, Jim. Anyway, I
but
say
some
this.
lawyers even call us justice, so judge, you stick with judge, so that works, yeah.
Okay,
Yeah.
well, right now, I'm going to call you guys esteemed, honored people that I am in awe of just being here, and I'm an emotional person, so I apologize.
well, we're glad
Because
to-
I'm a performer. I'm a music performer.
We're glad to have you here
Thank
today,
you.
and we look forward to what you have to say.
Thank you. And if you could you can go ahead and start. If you don't, if you could use that frame of reference that I'm a performer, and because I'm a performer, there are ways that we learn our music, and the way we learn our music is through different languages. And the first time that I might sing a song in French, in particular, I might take that piece and I might sing it directly, but then in time, I start learning the beautiful language and then start singing this beautiful piece of music and understand it more. And as you, I pray, have seen, at the beginning was the beginning stage of me learning this language. Bless you guys. It's very confusing as I was listening to other people, but it's not anymore. I was sitting here and actually following those other two appeals, and I didn't realize that it's, how do you pronounce that word? Because I say appellee, and you guys said,
That's
I just learned something today. So the language itself I don't understand, but I have been learning. But I do know that, yes, I do have trouble with not following rules when I know what the rules are. And I know from the very beginning that the truth should always prevail, because the Lord has sent me here at this time, at this moment, to protect the rights of all teachers, not just mine. Because what has happened, and how Counselor Nolan, he said I could say Mr. He was very kind in explaining everything to me today, and thank you. But I am not afraid. I'm not afraid of losing my job. I'm not afraid of saying things that might actually come against me later because it's the truth. I am done with CMCSS bullying, telling us what we can and can't do, and then sending things to the extreme in order for me as a pro se, as a teacher, an educator, somebody who, yes, sir, and it was so great to hear your voice because I haven't heard it yet. When you were asking questions about can CMCSS get in trouble, absolutely. And that's who I work for. I want to make sure they don't get in trouble. That was the whole purpose of this website. It was because during COVID, we did not have the opportunity, nor the time, nor any sort of possible way for us to be able to communicate to where we did not put everybody's address into so-and-so. If there was a family that was divorcing and they didn't want their email address to be known to their other person, I, as the teacher, would not know, and I would have to put it in BCC. Do you realize that during COVID, that had never been told to me? And I was sitting there at my kitchen table, happened to ask the question of another teacher who lived with me at the time, and my husband, I said, what's BCC? My husband is a computer engineer and gave me a look of, I can't believe I'm married to somebody who doesn't know what BCC is. And so then he informed me, BCC means carbon copy. That means, and I went, oh my goodness. And at that moment, I received an email from my son's teacher with everybody's email address into. And I went, you can't do that. I just found out you can't do that. So through that, I was able to inform another teacher. Through that, possibly another teacher. But my husband, he said, I can fix that for you. Really? How can you do that? Let's create a website so that you can have transparency, because I'm a music teacher and was given one class of sociology at the time. Why? Because you get along with the kids. There's a rule that says that if you don't follow things, it's called a deviant theory. Are you kidding me right now? There's a deviant theory, meaning that if I don't do what I'm supposed to do, there's a theory and it's okay. I was studying sociology, trying to figure, what is this stuff? And emailing all these people. But let's get back to the truth. That was the truth. Let's get back to what I'm trying to talk about. So, the very first thing, he referred to an email by David Holman. He did not give you the beginning, where it states that David Holman received a phone call from Chris Pugh. Chris told me that a teacher created a website as a workaround for sending out newsletters to parents. I was told that the teacher could not use email to send the newsletter because she was concerned about emails that were sent with blind carbon copy, because at that moment I replied and I saw blind carbon copy and I said, wait a minute, Peyton, it said that I'm not supposed to be able to see who this was sent to. It really confused me. So Rebecca Byrd, took it upon myself to tell technology person, hey, I hit reply all, but not only that, hey, we have a solution, it's this website, but my husband came to me and said that there is a private policy and I need you to go over this. Whoa, wait a minute, CMCSS has never had me go over private policies. I don't know if they're gonna be okay with this. Let me see, I'll go to Chris. I went to Chris. The next morning I come to school. There were two gentlemen facing the wall. My principal is sitting right here leaning back in his chair. There's another assistant principal supposed to sit there and didn't. There's another chair left open for me. I walk in, nobody stood up. My father told me, you introduce yourself and you stand up. When I walked around the corner, the Lord told me, introduce yourself. I turned and I said, hi, I'm Rebecca Byrd. Oh, gentleman stood up. I'm David Holman. Oh, you're here about the website. You know about the website? Yes, I know about the website because I'm the one who told Chris about the And it states right here that he told the principal, do not tell her we are coming. Not only that, it also states he was on speakerphone and the superintendent was there listening. And he asked, what should I do? That's the beginning of this entire thing. So, where I should have started before, if it pleases the court, my name is Rebecca Byrd, and I'm a teacher with Clarksville-Montgomery County School System. And I am here to defend the decision of Judge Dean to be insured to have the improperly reported discipline supplied to the state Board of Education, he failed to say that. Not only is it there in my record, it cannot be removed. Cannot be removed. Because in 2018, they passed a bill that said that if you send it, we keep it. Unless the State Board of Education says it will remove it or a viable court. So yes, FERPA is so very important that it will stay in your record, whether you have been terminated or not. The day I went to defend this was the day of my suspension without pay. So when he says I had due process, the day of my suspension, that I asked, I said, when do you want to meet? They said, how about March 29th? Oh, perfect, I'm off that day because you guys made sure I didn't go to school that day and I'm not getting paid for it. Sure, I'll meet that day. What time? I got the whole day. So here I am, trying to do what is right for my students because that is what I'm called. But I'm going to tell you, Romans 8:28 comes into play. All things work together for good. Why is that? Because in my appeal, it states, we need a messaging system. We need to be able to contact our parents, contact our students. It needs to be auto-populated. Lo and behold, Parent Square. I am very glad that this happened because that company came out in 2017. This is now 2022. If we were to have pursued, like, whoa, we need this, a company had already started this. Why didn't CMCSS already have it? Why didn't CMCSS already look into how we can do things for our teachers so that we are not emailing all these people? I'm a musician. I had to convert everything over to PowerPoints. And then I was held accountable for every little thing that I said because it says it in writing. So I come to you today because I deserve, and I never thought I would have to defend my integrity that was stolen from me, because that meeting was never recorded. That meeting was never auto-recorded or hand-recorded. The people who were present were David Holman, Stephen Wynn, my principal, Dr. Parham, who is the assistant principal, Dr. Bailey, the principal, and me. And me. Stephen Wynn, David Holman, Dr. Bailey knew about the meeting. Dr. Parham brought in. Rebecca Byrd, will you please come to the conference room? The rest of it, the Lord has placed in front of me because Mr. Nolan on December the 28th decided to send me record that says you need to follow these statutes because the court says so. Oh my goodness. Wait, there's no clerk stamp and there's no judge's signature. I'm not doing anything because the law says I don't have to. And believe me, I researched for forever. My husband knew immediately, you don't have to. And I went, no. I gotta make sure. This is my reputation, this is my life. And then on January the 3rd, he filed. Never sent it to me. I got called to court June 21st, 2023, in a briefing. The whole time I'm listening to all this stuff going on. And then that question that was asked during that briefing that should have never happened because it was never really done. I'm sorry, you didn't follow the rules. I thought you knew the language. I had to stand there and listen. And it wasn't until they finally asked Dr. Huff, what else could you have done? Could have done a letter of reprimand. I said, Your Honor, you don't understand what a letter of reprimand is for a teacher. It ruins our career, our integrity. It ruins everything we've worked for. And most importantly, it ruins the love and the care that we are there for because we have to leave the profession because we have been under violation that I never did, which the memorandum proves. We have the CMCSS law in one column, we have the federal law in the other column, and it checks out. Not only that, Mr. Nolan, thank you so much for reminding me about footnotes, because I would have totally forgotten about it. But it says, the court finds that equity, let's go on to for information is FERPA. Oh, it's all, why did the judge go and research all this stuff? It's because the judge didn't know about FERPA. He didn't understand FERPA, and he said it over and over and over again. And because he didn't understand it or didn't know it, I have to tell you that Judge Dean did exactly what he should have done, just like what I would do as a teacher. If I don't understand a question, I don't even call myself a teacher anymore. I call myself a facilitator. Why? Because these kids are way smarter than I am in certain areas, but I am the subject knowledge. I had the subject. How we go about doing it is something different. Judge Dean, being an expert of law, understood and humbly admitted his unfamiliarity with FERPA laws and conducted his own research to compare the wording and meaning behind the evidence given during the trial and other similar entities to make the best informed ruling possible based on the facts and understanding of the merits of the case. Judge Dean should be commended for making sure he left all biases out of the courtroom when making his final judgment and carrying out the oath he made while he became a judge to have a fair courtroom. Educators are responsible for making all classroom equitable to the students, and Judge Dean pointed out that the same consideration should be considered, especially when the merits of the case have strong implications for all certified teachers within CMCSS if the behavior of CMCSS were left unchecked. Yes, we don't want to be micromanaged, but CMCSS is out of control. Out of control. We are afraid of losing our jobs. We are afraid of being reprimanded. We are afraid. I used to be the representative of my school, and people refused to write down anything that would lead back to them. They would leave me anonymous printed out papers in order for me to bring a complaint because they were so afraid they would be blackballed. All I have to say is that I am here for this reason, this purpose, just like Esther was when she married a king, and she was brought there in order for her to save her people. My people are the teachers, but more importantly, my people are the students. We are being pulled from hither and yon. I went back to school, and I have another degree called Education Innovations because of sociology. Because of this, I was a master's student, a teacher, and a lawyer. So I pray that you guys understand this is more than just what Mr. Nolan brought up.
Thank you, Ms. Byrd, for your argument. Thank you very much. We'll hear rebuttal from Mr. Nolan.
Briefly, Your Honor. Ms. Byrd just referenced violation of due process when she didn't have an attorney at that initial meeting with the principal February 28th. 495-512 says when you have certain protections, such as we're going to keep a record or recording, have a right to an attorney, and that would have been when you meet with the director March 29th. So the record will show that we did comply with when she had certain due process protections, and we complied with that statute. Just because there's an investigation doesn't mean that you have a right to have every part of the investigation from start to finish recorded, or you have a right to have an attorney there. This is not a criminal proceeding. So we comply with the statute. So there's not a due process violation. And then briefly, Judge, just to bring it back home, as I was talking about, the chancellor under 495-513, it specifically says the review of the court shall be limited to the written record of the hearing before the board and any evidence submitted at the hearing. What the chancellor was looking at was there a basis for the decision? He finds in two separate places that he even saw that there was, although he considered it a technical or minor violation of FERPA, paragraph number 28 and another paragraph, 33, that there was a violation of FERPA. That's what she was disciplined on for 1 day. So the court saw the same thing that the director did. And so we're just gonna look at what the court should have done was said there was a rational basis for that, and therefore I'm going to affirm the decision. It does not say, go do your own investigation. Don't have additional testimony unless you're trying to establish that it was arbitrary or capricious or a violation of a statute or constitutional right. The court didn't find that anything was done arbitrarily or capriciously, or there was a violation of statutory right. So the court did its review, it just came to the wrong conclusion because it went outside of the scope that's allowed by the statute.
What are the consequences for Ms. Byrd of if this is upheld? There's a report made to the state, and it stays there that says she was suspended for violation of, for
Correct.
1 day for violation of
We are
FERPA.
required to report discipline. The report, and in the record it says that although this was reported to the state, it also went with another, that the district did not recommend any other thing be done to her license. She's remained employed. She would have received the same raises that anybody else did. So there was nothing beyond essentially not getting paid that day. And so I would ask the court to overturn the decision because the chancellor went outside of his scope, and as we just discussed previously, it just wasn't initiated timely. When you look at the letter, it says, I am asking for extra 60 days. That's a motion. It's not a petition. It's not a sworn statement. Thank you.
Thank you, Mr. Nolan and Ms. Byrd, for your arguments. We'll take this matter under advisement. That concludes the morning docket. Judge Cottrell and Judge Ash, if you would bring your guests back, we'll be glad to visit.